About to bring everyone a live press conference that's going to be taking place. Let's tune in right now. This is New York Teachers for Choice.
People are still joining as expected, and we'll start at 4:05.
Thank you.
I know members of the media have deadlines, and I apologize that this had to be so late today, but it's been a very busy day here.
New York Teachers for Choice has just filed suit. We're going to be hearing all about it in just a matter of minutes. Crowdsource the Truth viewers will recall New York City public school teacher Michael Kane has joined us a number of times. We're just waiting for the press conference to begin.
Michael, there are 20 participants so far, which for a few hour notice is a good number. If there are people in the group who need to get more information, obviously they can get in touch with me directly, as you know. Some may not have been able to join on such short notice.
This is Michael Sussman, lawyer for the New York Teachers for Choice. He's going to be starting the press conference momentarily. Heavy snow expected here in New York City for Wednesday when the Department of Education protest is planned. It remains unclear if that's going to be possible, so we're hopeful to learn a lot from today's press conference. We're just waiting for attorney Michael Sussman to begin. Several members of the teachers union are joining the call.
All right. I think we can begin. And good afternoon to everyone on the line. I'm Michael Sussman. I'm a civil rights and constitutional lawyer in Goshen, New York. And today we filed in New York State Supreme Court a hybrid Article 78 and declaratory judgment action on behalf of parents, teachers, and a staff member associated with the New York City Public Schools. I wanted to do this briefing because it's very easy to misunderstand the nature of the lawsuit and its intentions. And I want to do what I can to mitigate such misunderstandings. Having dealt with the press for more than 40 years as a civil rights lawyer, I know that misunderstandings abound. And once they begin, they're hard to themselves disabuse people of. This is not a suit opposing testing in the New York City School District. So let's be very clear first about that point. There may be people who oppose testing, and they can have their lawsuit litigated in another forum. This is not that case. This is a case which says that individuals, whoever they may be, who subject themselves to testing, have a right to know that no company which has proprietary interests in DNA databases will be benefiting from their specimen. Some of you may know the story of the courageous woman who was fighting multiple diseases at Johns Hopkins University. And unbeknownst to her, those scientists and doctors took her tissue and replicated that and utilized it for literally generations without telling her, her family, or otherwise. It's a famous story. I believe that individuals who subject themselves to testing should know and be assured that the specimens that they give will be destroyed upon the result of a test, period. It's no more complicated than that. Now, the New York City Department of Education, in my communications, which are attached to the complaint, has stated as much. So there doesn't seem to be a disagreement on the issue. However, When asked to produce the agreement with Fulgent Genetics, a company which is known to have a proprietary database, has refused or failed, whatever word you want to use, to produce the agreement by which that company is prohibited from otherwise using the specimens. If there is such an agreement, it should be produced. If there is such an agreement, not such an agreement, excuse me, there should be no representation made to members of the public that there is such an agreement, or that Fulgent Genetics is going to have to comply with that very basic principle. So this lawsuit is narrow, and it says that no one should be punished for refusing to subject themselves to a test unless and until it is known meaning the court and I and whoever else wants to see it can get a copy of the operative contract. Whether it's DOE, whether it's some other department of the city, seems to me immaterial. There needs to be the production by DOE, which has its agents, after all, cooperating with this and is trying to get them and essentially force them at pain of being on unpaid leave if they're faculty members and not admitted to the school if they're students. That's significant pain. So before you subject yourself to someone to that pain or anyone to that pain, you better be able to produce the operative document. And frankly, I think it's polarizing in this climate for city officials who want the testing to succeed, and they have good reason to, I don't doubt that, not to make available what should be a bedrock document to those who have been asking for it, by the way, Mr. Kane amongst them, for several months. This is not somebody who just immediately ran into court. There have been efforts made by other attorneys, by myself, to get the document so that we could be assured and assure our clients that they were not going to be subjecting themselves to having their data, their DNA, stored and used by someone without their consent. The city should be able to ameliorate the situation and resolve it in 5 minutes. 5 minutes, maybe less. By now, it should be 1 minute because they should have the document. They should be able to put it in a scan, send it to me, and that'll be the end of it. But when that request was made in a polite manner, in a professional manner, it was met with, we don't have it, someone else has it, nonsense. So, it's a very polarizing time in our country. It's a polarizing time in our city. I feel that polarization needs to be met with transparency. And I think if there is transparency, those who want to polarize are frankly wrong on all sides. But you cannot call them wrong if all they're asking here to do is see a document which guarantees that this right, which everyone apparently acknowledges, because the city school department didn't say to me, no, we can do that. They said, no, we're assuring people it's not going to happen. So that assurance, though, in this context is not sufficient. Where there's a document that should in fact end the discussion, it ought to be produced. And remember, this is a public body. We're not talking about a private entity here which has some right to hide whatever document it wants to hide and is not governed by FOIA and has some other interest. No, this is a body supported by taxpayers in the city of New York. It acts in their name. It should be acting on their behalf. And on their behalf, it should certainly be able to guarantee that what I've explained here today, and which represents many of the individuals involved, is assured. So that's really what I have to say. An injunction is being sought. There is an assigned judge, and that judge will follow, obviously, whatever practice she does in hearing the application. I've not heard yet from the court, but we only filed this a few hours ago, so that's no surprise and no criticism of anyone. We'll be prepared to argue the case when given that opportunity. But as I say, this is something that should be resolved very easily through the presentation, and certainly the media too has a right to the document. The media has a right to know as a representative of millions of New Yorkers, and you are a representative. So anybody has any questions, or Mr. Kane, you or others may want to make brief remarks. I have no problem with that. I just want to be sure we're on issue here.
Yeah, Mike, I would like to say a couple of things. First,
Please mute, hold on. Please mute yourselves. You have children in the background. So thank you. All right, Mr. Kane, I'm sorry for that interruption.
No, not a problem. First, I just wanted to thank you, Mike, so much for just articulating the issue so clear and so well and so better than I ever could. The one point I really just want to add to that Mike had brought up is that there was many months of us seeking out answers. First, I reached out to the UFT, my union. They didn't have any answer for me. Then we were reaching out to the DOE and the chancellor. Not only no answer, no response. They didn't even say email received. I had nothing from them. So we ended up having an action alert. And I'm so happy to see so many people on this call right now that are parents and teachers that have been involved with me. Hundreds of us reached out to UFT President Mike Mulgrew, to DOE School Chancellor Richard Carranza, to Mayor de Blasio, asking this exact question that our attorney is now asking, and all we got were crickets. That's all we got. They didn't even acknowledge us. So as we're seeking out answers from our employer or for where we send our children to school to be completely ignored, what type of good faith is that giving us? What type of trust is that creating when they're asking us an unprecedented ask? They're asking us to submit ourselves to COVID testing in school, to trust them with taking our specimen, and they've provided no response to us. When Mike Sussman reached out to them, they started to respond. When he was good enough to represent us, he apparently met the standard of somebody that the DOE felt should get a reply from. But me being a 13-year New York City public school teacher, they gave me no reply. So again, I just want to thank Michael so much for doing everything that you're doing on our behalf. I just really, really greatly appreciate it. I think that's all I have to say. Thanks so much.
Now, there's a question for Mr. Castro. What happens in the event that no such agreement existed and the collection of specimens had taken place? What happens is that a judge should enjoin any further collection until there is such an agreement, or until, if there is no agreement, the sponsor comes to court and indicates what it will do, which is to destroy the specimen, and makes a binding legal representation to that effect, not only with regard to any future specimens, but anything they've collected. You know, the suspiciousness here arose because it's known that one of the proprietary companies does maintain such a database, and it seemed logical that one of the reasons they might be involved in this was to, in fact, inure to their own proprietary advantage and increase their database and augment it, which again, you know, they may have every right to do under certain circumstances. And it's also the fact that maybe people will consent to having their data in there. That's a totally different issue. That's a totally different issue. That's not the same as saying that someone can be coerced into giving their specimen without that insurance in place. And what's shocking to me is that there are, in fact, children who are being denied admission to school and teachers who are being ostracized, stigmatized, and not paid because they're refusing to comply with this kind of a regime. And this is very problematic. We have all sorts of people who want to run for mayor. I'm not one of them. I don't live in New York City. I live in Orange County. I don't have any political stake in any of this. But I do feel that there needs to be some principles that we operate by our institutions. One is transparency, but another is a fundamental, please mute yourselves. And the other is a fundamental regard for basic principles. Privacy is a basic principle. Not having yourself trespassed in this way and then being punished for any talkback, that's a pretty basic principle of anti-retaliation. Now, the other thing to say about this, and it's a little beyond the lawsuit, is if you have a testing regime which is only testing 20% of your teachers to begin with, why in God's name would you be suspending a teacher who doesn't want to give their data? What logic is there in that? It's nonsensical to begin with. Take volunteers and have the volunteers come and give their data. Now, it's one thing if you're going to enact 100% testing, which should have probably been done honestly 9 months ago. You're really serious about this. But what in the world is the point of punishing a person when you're not having a mandatory testing model anyway? That would be everyone has to be tested. The other incoherence is, I've had 2 tests. Many people have tests. You bring your test in. You get a letter, for those who don't know this, from the New York State Department of Health My son just got one. I opened his mail. He's going to be very upset with me, but I'll admit it publicly. I wanted to see it. And it says, your test came back negative. Now, the New York City School District is claiming that that's not enough. You come in with that, they say that's not enough. We won't take that. That's also absurd. We have scarce testing resources. I assume that's why we're only testing 20% of the people. So what sense and logic does it make to say, is there so much fraud? There's fraud everywhere, apparently, in our society. Under every block, there's fraud. Well, it's ludicrous. So there are other problems with this, but these are problems not directly addressed by this lawsuit. This lawsuit is more narrowly focused. It's about privacy and it's about transparency. And for those joining late, I'm repeating it just because I know you weren't on. You have 33 people on the line and some joined later. If anyone has any other question, we have.
Could I mention something, Michael? It's
Yes,
Renee from
please.
Staten Island. I'm a steering committee member.
As long as it's on point.
Hi, Mike.
Yeah, fine.
I just want to mention something. As far as in the vein of what we're discussing, what they are doing with these DNA samples. So specifically at my school, PS 36 in Staten Island, they have tested the population 3 times, and all 3 times they have tested the same cohort group, and they have attempted to test the same people, which gives a lot of credence to the idea that this is not being done for safety, because if you wanted it done for safety, you'd attempt to test as wide a swath of people as possible across all cohort groups. But if you're testing the same population 3 times, that sounds like a 3-round controlled variable trial. And it kind of gives credence to the idea that if they also don't want to disclose what's being done with the DNA, there's more to this than meets the eye. And if they were forced to disclose the contracts, the entire thing could fall apart.
All right. Well, we're trying to force that disclosure, as you know. I don't want, quote unquote, the entire thing to fall apart unless the entire thing is something which is being perpetrated without the transparency for some other purpose. And then that's a different issue. I mean, I said to you earlier in this group that I don't understand the testing regime to begin with, which is this limited. Because quite honestly, I don't know what anyone in their rational mind could give it assurance based on that kind of testing about anything about the school environment. It really doesn't make a whole lot of sense. It's one thing to stand at the door and say, come here with your private test, show us that it's negative, and then come into this building. Okay, we all know there are problems with that because the test is one snapshot in time to begin with. We understand the imperfections. I've never wanted to set the ideal and perfect against what may be helpful. It may be helpful, but it has its share of problems. But this kind of lack of transparency does foment the exact suspiciousness you raise. And I said the same earlier. I'm not in any position to say to you, you're wrong. I have no idea. I don't know if you're right or you're wrong. The city should have an interest in a time when they know that many people are highly suspicious of government, especially in the area of vaccinations, of testing. It's all we're hearing about. Only 50 or 60% of the people say they want to take a vaccination in the middle of what we're going through. That speaks to a very significant public health issue, okay? Because you might have a perfect vaccine. It may be great. Who knows? We don't know yet. And yet you have almost half the people saying we don't want any part of it because we don't trust the people who are in charge. This gives weight to that kind of thinking. I oppose that kind of thinking because I don't take that view, but I understand why people are taking that view. And those in power have got to be more responsive and more responsible, or this is simply going to continue down that path. There are some other questions. Let me just address Mr. Castro. In the future, would you be willing to support educators in a legal battle against the mandate vaccine? Because this seems to be the direction the DOE is heading, with this lack of transparency and lack of individual rights. So again, we're not going to discuss that today. And the reason we're not is I'd like to keep the focus on what is today. Today is about this issue. There'll be another day, maybe not. And if there is, we'll deal with that. Is someone recording this? I don't think so. This is Ms. Gregory. What do the petitioners feel will be done with the DNA data? Is Fulgent Genetics one of the companies that are proprietary DNA database? The answer to your second question is yes, they are. The answer to your first question is petitioners have different fears. They don't want their DNA data in a database. In New York State, just so we're clear, and I recently litigated this case up in Columbia County, where the district attorney of Columbia County wanted DNA samples from 7 people. And the judge denied him that right in a decision. And in that specific case, the individuals did not want their data to be in a database. They did not want any dissemination of their data. They did not want any invasion of their privacy. From that DNA data, one can discern what illnesses they might have, propensities they may have. You can discern a great deal from DNA databases. They didn't want themselves subjected to that. Whatever their reasons, it doesn't matter. It's like saying, why doesn't somebody want their photograph put on the New York Times front page? Who knows why? But they don't. They have a right not to. Okay, that's why there are releases signed at press events so that the press can in fact publish with certainty that nobody's going to turn around and say you're using my likeness for commercial gain and sue them, which you can do. So everyone has a right to make this decision, whatever the basis of their fears. We're not getting into why all the petitioners had specific reasons. They have their reasons. Mr. Kane, you can address that if you want, or anyone else.
Yeah, Mike, I'd just like to add 2 points to what you said. One is that the DOE in the beginning of this played a small sleight of hand with us. They released a non-disclosure data processing agreement, which basically kind of said all of the student data, nothing will happen with it. But the specimen itself, that's when they swab you, and what is actually physically on the specimen, they've released nothing about that. So the physical specimen is stored in a library, in a genetic library. They've assured us data is safe, but they've assured us zero about the specimen in any such library. So we don't have that information right now. And the second thing I wanted to say was, it does look like Jason Goodman from Crowdsource the Truth is recording this, and I think possibly broadcasting it right now. So if anybody wants a link to that or to know how to get to it, just send me an email from our contact page at New York Teachers for Choice.
Thank you. All right, Mr. Block, is there any intention of a lawsuit to prevent the COVID testing mandated in and of itself? For instance, even if the contract is above board, many parents will not want their children tested in the schools frequently. It's not fair to children, and some teachers are not willing to cooperate with the DOE, et cetera. Look, I think that we wrote, and Michael and your group, I think, approved of this approach a month or more ago when we wrote them initially. And what we said to them is, if you're going to be doing such testing as you're doing, which then wasn't even 20%, I think when we first wrote it was 10%, it was a smaller percentage, then please get volunteers. I'm positive you're going to have enough volunteers. I'm also sure, as we've been talking about, that there are many people who do not want their children or themselves associated with this for whatever their reasons. And the city should have proceeded, in my view, in that way. I don't think we need to make this a truth test for people. I don't think we need a loyalty code in our country. There are people with all sorts of ideas, and to the extent we're going to have a public policy which is uniform, that's one thing. But if we're not going to do that to begin with, let's not make it a battleground. There's no need for it. And the public policy thus far, even deep into the second surge, is 20%. Well, if that's what they really want to do, and I don't disagree with Mason, I don't know what the reason may be, because it's not rational. And that, to me, means that, if someone wanted to make a different kind of challenge, they could. Our challenge is the challenge we're making right now. I think there's a reasonable argument that anyone compelled in a circumstance where they're only asking 20% of the people could do it could say it's irrational to begin with. What are you talking about? Doesn't make any sense. The whole thing doesn't make any sense. Why would you compel me if you have 50% of the people who want to do it? You have no need to compel me. What about me is causing you to select me and exclude me if I won't participate? Not very logical. And again, as I've tried to say, in a time like this, where we have all sorts of disputes, I don't know why a government would be so insistent on being illogical. The CDC, Ms. Veselou, says it is unethical and illegal to test someone who does not want to be tested. Okay? So that is true. The CDC has said that. It is in their guidance. And there is supposed to be informed consent for medical procedures, and this could be considered a medical procedure. So you have that as well, which is bedrock constitutional law. And that can only be overridden in certain urgent situations, but it makes no sense to claim that this is that situation when you have a 20% testing protocol. So you have illogic all upon illogic. And I would like, if the media is here, I'd like, and I hope that you will emphasize this, because the city needs leadership. I don't know who the leaders are going to be there now, but they need leadership that will be more logical and consistent. Okay.
Yeah, no shit.
Does anyone else have any questions? Anyone from the media can ask you a question verbally. That's fine. If you'd like to unmute and do so, you're welcome to do that. If not, we're going to end the conference because I think the points that we needed to make have been made. I don't want to prolong it and keep people. I know everybody's very busy, and I appreciate everybody participating. If anyone who's a petitioner and plaintiff has a question, you can contact my office and we'll try to answer your question. It's sussman1@frontiernet.net or sussman1@sussman.law, one or the other. And if there's any other issues that need to be taken up as this develops, we'll take them up. I don't want to get into today the vaccine issue because it's a really different issue and it has its own dynamics. And we're not there yet. Whether we will get there or not, we'll see.
Mr. Sussman,
yes.
First of all, thank you so very much for everything to you and to Michael Caine and for everybody. It's so great to see like-minded people working together. Who chooses this 20% to be tested?
Well, that's a directive that, as I understand it, is a DOE directive. So when you say who chooses, my assumption is the chancellor chooses. I have no idea what their decisional process is, but ultimately the buck stops there. So he and the mayor basically, as we know, run the school system regarding every issue, including an issue of this importance.
No, we were told that the DOE comes in and selects names off of a list. It's not our principal that selects.
You mean who decides who is in the 20%?
Yes, I apologize.
I'm sorry, I misunderstood your question.
No, I did not make it clear. I'm sorry.
Sorry.
Mike, I can actually talk to that a little bit.
Speak to that.
The DOE is a behemoth bureaucracy. So these orders are given out and then they go to superintendents and then assistant superintendents and then principals. And each principal and how they interact does it differently. So what you're saying happened in one building, I know another building where the principal actually made sure certain people weren't on it. There's unfortunately no completely standard way of doing it. That's how
I thought so. I thought so. Thank you for verifying that. Because we're being led to believe that it's not our principal, it's the DOE. And
hold on, we have news. We have news.
Oh,
we have
great.
news.
Thank you.
Sorry.
Thank
The
you.
judge has scheduled this case for oral argument on our request for an injunction at 11 a.m. tomorrow morning.
Yes.
I will send to Mr. Caine the information. Typically, and I say typically because it can vary. These are supposed to be what are called public proceedings, as if we were in a court, and you would have a chance to, if you will, as you're doing now, join in. I can't be 100% sure of that. I don't know how this will work, but that would be my working assumption. So both from the media's point of view and those who are plaintiff petitioners and otherwise interested, we will send through Mr. Caine the link and he will distribute it, okay? So that's 11 o'clock tomorrow. We just got word from the judge. That's why, sorry to interrupt you, Anna, but I wanted to make sure people knew that. Okay. Anyone else want to make any statements? Okay. So we will be back with you tomorrow at 11, those who can join in, and I hope that those who are interested can join in. I do believe these proceedings should be transparent to the public, but again, the courts are operating with the technology they have and the issues they have. Let me make one other thing clear. We're doing the medical exemption case statewide. As some of you may know, the New York State Department of Education has been very stingy in the way it's proceeding with medical exemptions for students in schools. And Sahada Gibson, Mary Holland, and I have been challenging that constitutionally on a state level. We did have a call with the judge at one point, I believe it was in October, about 350 people signed in for the call and got on the Zoom, but many of them forgot to mute themselves. And we couldn't even do the argument that day. We had to do the argument another day. While it was wonderful for there to be such a great expression of support, it also stymied our ability to try to get the injunction because we couldn't argue. So please, if you join the call tomorrow, and Mr. Kane, when you send this out, please emphasize to people, you have to mute yourselves so that we can have the court proceeding. It's not helpful to join in and be interrupting it and thereby preventing us from doing what we need to do. Okay.
Mr. Sussman,
Yes,
real quick, could the outcome tomorrow be a possible stay of the testing until the contract is produced? Could that happen tomorrow?
Yes. I'm not saying it will happen. You asked, could it happen? The answer to could it happen is yes. That's what we're asking the court to do. But the court has to hear argument and is doing that in a very prompt way, which is very appreciated. And we will see what happens. Okay? Everybody clear?
Excellent.
All right. Thank you all for being on, and we'll stay in touch. Good day,
Thanks,
everyone.
Mike.
Thank you
Bye,
so
everyone.
much.
Take care.
Well, there we go, everybody. That's the press conference from the lawyer for the New York Teachers for Choice. They do have a protest scheduled at the Department of Education in Staten Island for Wednesday. Question remains if the weather will allow it to proceed. I want to remind people that if you are interested in putting your support behind the New York Teachers for Choice and helping them with their lawsuit, remember this is an Article 78 action intended to compel the Department of Education to do something. You generally can't bring normal kinds of civil suits against these government agencies because they have indemnity, but of course going to court, doing all these things, it requires money. So people can go to GoFundMe.com. If you just Google GoFundMe and lawsuit against NYC DOE, you're going to find it. You could also go to NY Teachers for Choice. That's NY Teachers, FOR Choice.com. And if you click on the Updates tab and you scroll through there to the lawsuit, and if you just read that, you have links to the GoFundMe in there. I just want to make sure that everybody was aware of what is going on here in New York. Today is the day that Andrew Cuomo announced the first recipient of the mRNA vaccine. The Pfizer vaccine was an emergency care nurse, and she's received the vaccine this morning. The primary consideration for the teachers there, everybody heard, is sort of an arbitrary approach to testing only 20% of them. I don't understand how that would help, but they're very concerned about storing of their DNA and their samples. And as I was showing throughout the broadcast there, Gordon Chang has been publishing his information in various news outlets. He alleges that China has been collecting DNA data on its own citizens, and they're trying to database everybody's DNA. As the lawyer, Mr. Sussman, stated, it's really unknown what can be done with this DNA. Obviously, genetic technology is in its earliest stages. Presumably at some point, if somebody has your DNA, perhaps they could clone you. I know that might sound fantastic, but people will recall there was already, I think there's been several mammals that have been cloned. There was a sheep, I think some dogs, a lot of different animals could be cloned, so nobody knows what they might do with your DNA. The point is, these teachers are fighting for people to have the choice rather than to be forced what to do. So if you work at a job and you're concerned that your job might force you to get a COVID-19 test or perhaps a vaccine, you may want to choose to support the teachers, New York Teachers for Choice. If you just search Google for GoFundMe lawsuit NYDOE, Department of Education. that does bring you right to it. So that's going to be the easiest way for people to find it. $5, $10, whatever people are comfortable sending. I think any amount would help. They've reached their goal of 5,000, which is very good. I think it's probably still a good idea to help them with some funding, because it seems like legal actions always cost more than you might expect they would. I'm going to wrap this broadcast up now. I want to thank everybody for watching, and I want to remind you that I can't bring you broadcasts like this without your support and sponsorship. So please visit subscribestar.com/crowdsourcethetruth or patreon.com/crowdsourcethetruth and become a sponsor. Thanks for watching, everybody.